All right, welcome back. One quick question or quick answer to a question that has come up. These sessions are all being recorded. The video version of these will be available on the same website that you're watching it on, probably by the end of next week. So yes, they're all being recorded, and you can check them out later as well. All right, so a great panel coming up called Managing the GDPR After a Data Breach. We have four terrific panelists. Let me first start by introducing Cedric Burton, a partner at Wilson Sonsini in Brussels. He co-chairs the firm's global privacy and cybersecurity practice and is the managing partner of the firm's Brussels office. He also leads the EU data regulatory practice. He has nearly 20 years of experience and is a go-to lawyer for companies in high stakes and complex regulatory investigations in Europe and throughout the world. Welcome, Cedric. Let me next introduce Kelly Hagedorn. She's a partner in Orrick based in London, but she's joining us from Paris today. Thank you for that. Her career includes secondments to the UK's Serious Fraud Office, where she worked on a number of cases dealing with restraint and confiscation matters. In the GDPR area, Kelly designed and implemented data protection compliance programs for clients in a range of sectors, including technology, gaming, manufacturing, private equity. Kelly, it's great to have you with us. Thank you.
Thank you.
Anne-Gabrielle A. She's a senior associate at Cooley in Brussels. She practices with a focus on data protection, cybersecurity, and AI, and counseling clients on compliance with European privacy laws and risk management. She also has strong experience representing clients in enforcement and litigation actions. Welcome, Anne-Gabrielle. Finally, our moderator today is Spencer Lynch. He's a managing director for Strauss Friedberg in its London office. Strauss is now an Aon company. Spencer and his team have led and performed preservation and analysis of thousands of digital devices in data breach investigations. He's been accepted as an expert witness in digital forensics by courts in the US and the High Court in London. Spencer, it's great to have you with us. Welcome.
Great, thanks, Bruce.
Let me turn it over to you.
Great. Well, welcome everyone to Managing the GDPR After a Data Breach. Hopefully at this stage, everyone is aware that if they were to suffer a data breach, they have to consider the regulatory obligations and possibly notify a regulator, and that there's a 72-hour kind of window. So we won't cover some of those basics, but do want to kind of dive into some questions here. Because in my experience, while those kind of high-level concepts are pretty easy to grasp, it's not necessarily that simple, particularly post-Brexit, figuring out who the regulator you might have to notify is and when specifically that happens. So I wanted to start with a question, maybe I'll direct to Kelly around how do you assess who you need to notify? Is it always necessarily a single authority? And what factors are you looking at when figuring that out?
Thanks, Spencer. It sounds like it should be a straightforward question, doesn't it? Which of the regulators do I need to notify? And for some of my clients, it is quite straightforward because either they just have one single presence in Europe, so they notify that regulator. Sometimes they have an obvious center of operations in Europe. And perhaps they're based in Paris, but they've got locations in Germany and Spain, Italy that are smaller. So the obvious regulatory authorities, the CNIL. However, I had a client recently who had no presence in the EU at all, not in the UK. They were entirely based in the US, suffered quite serious data incident, but are processing the personal data of millions of EU and UK citizens. And at that point, we had to look at ourselves and say, well, who do we notify at that point? Because there isn't a lead supervisory authority. In fact, there isn't any supervisory authority that has obvious territorial jurisdiction over the client. So what we ended up doing at that point was notifying every single data protection authority in the EU, as well as the ICO and others, and trying to come at that and deal with that in the 72-hour window that you suggested, Spencer, is frightening, frankly, and a logistical nightmare. And part of the reason that we were in that situation is because the client had not even addressed the thought that they might have to deal with EU data authorities after a breach. And so hadn't thought about appointing an EU representative, hadn't thought about whether or not they could indeed designate a lead supervisory authority. And so if you're dealing with a smaller client or a client who's well prepared and has thought about their lead supervisory authority in advance, it's pretty straightforward. If you've got a client who hasn't, it's an incredibly difficult and complex situation to navigate.
Great, thanks. That does sound like it can be more complex than it might first meet the eye. So kind of if we imagine a client who's in a breach scenario, and let's assume that they have had to notify multiple DPAs. I guess there's a question kind of, is the process relatively the same? Do they all operate relatively the same way, or are there kind of vast differences? And maybe throw that to Anne-Gabrielle.
Sure. Thank you very much, Spencer. And this is a very good question, actually, because, I mean, if the GDPR has harmonized the criteria to assess the severity of a data breach and the time frame to notify such data breach, in practice, we see that EU regulators have a very different approach from one jurisdiction to the other. For instance, you have no harmonized notification form across the EU, which means that depending on the regulator that you notify, you will be required to provide different information. And that could be, of course, tricky, because that means that you need to gather a lot of information to make sure that you can address any question that you have to, or that you can address any information that you are required to provide. And another tricky issue in that respect is also that you have different means of notification. So, for instance, some regulators have set up online platform, while other do it by email. Certain forms are very difficult to get. For instance, in Belgium, they have put together a dynamic PDF, but in most computer, it's not working. So it's something that is also a bit annoying. And then you can also have language issue, because you do have some regulator that accept to receive notification both in local language and in English, but for other, they only accept notification in local language. So that means that probably you need to take into account that there will be some translation that will need to be conducted. And again, I mean, such different approach, such discrepancy are extremely challenging when you have a window of 72 hours, because 72 hours is extremely short. And if you need to deal with this practical issue, it makes it even more challenging. And then once the notification has been sent to regulator, we also see that from one regulator to the other, the response is going to be different. I mean, some regulators are really going to look into the issue, are going to initiate an in-depth investigation, sending a lot of questions to the notifying company, while others basically don't even acknowledge receipt of the notification. So it's really something to take into account, that if you have to do multiple notification, it can become tricky.
Great. Yeah, it sounds like it can be very tricky, particularly in the time frame allotted. I guess that's some of the logistical nightmare that Kelly was alluding to. So let's we continue playing this scenario out. You've notified a DPA or more than one. What happens next? What type of engagement might you expect? And I'll throw that one to Cedric.
So thanks, Spencer, and delighted to be here. So at that point, usually, and Anne-Gabrielle hinted at that, you get a few rounds of clarification. They want to understand, what happened. They're going to ask clarification on the facts, or if the form has not been completed properly, they're going to get back to you. So to Anne-Gabrielle's point, it depends a bit on the DPA, on their resources, on the culture, on how much they prioritize the breach, how much data breach they are notified to them on a regular basis. Some countries receive a significant number of data breaches, others a lot less. So there is no one-size-fits-all approach here. Just one comment on that. I have seen that too often. Just be careful about what you say there. everything you're going to say there can be used against you and will be used against you. So, in that context, less is more. If they have questions, they're going to get back to you. At that point, usually they ask for some compliance material. It can be the record of processing activities, can be security breach register, can be security policies and procedures, opinion from the DPO, you name all the accountability documentation that, companies are supposed to maintain. It's usually something which is asked at that stage. Once they gather that, then there's an assessment which is made by the DPA to look at whether they're going to investigate the issue or not. And so, you move from an informal inquiry into a formal investigation. At that point, usually there's a new department which get involved. And, if they start a formal investigation, in most cases, that means there will be a sanction down the line. Investigation means additional round of questions, can mean meetings with the DPA, can mean a downgrade. A number of clients got the visit of DPAs recently. So, just be ready at that point. The practices of DPAs will vary significantly depending on who you are talking to or who you are dealing with. And again, it's another reason just to be very careful about what you put in your notification form and in your reply to the DPAs. So some round of questions, downgrade meetings, they gather information. At some point, they're gonna reach a situation where they will feel comfortable that they have all the reply they need. And depending on the country, you're gonna get either a draft decision or a report, on which you will be able to comment. So, you'll be able to reply, to provide written observation to the DPA at that stage. And then you get into the formal proceeding phase, which might lead to a public hearing or not, depending on the jurisdiction. And, at the end of the day, you're going to get a final decision, which can go from nothing to fines, order to delete the data, can be an order, an injunction against the company to fix and remediate some of the issues. And of course, can be a fine, which is, the sanction which receives the most visibility in the press.
Thanks. It sounds like it can be a lot of work. We kind of talked through the process. If you're working with a client, who's kind of getting questions from the ICO or another DPA, and they're kind of in the middle of an investigation, is there anything that they can do to try and get ahead of the questioning and control the narrative a little bit? Maybe I'll start with Anne-Gabrielle on that one.
Sure. Well, I would say that it's really important, to anticipate a potential investigation, because, obviously, if a breach happened, then you're going to focus on making sure that it is contained, that you put in place remediation measure while ensuring that the business is still up and running. But it's also very important that you anticipate a potential investigation, because as Cedric mentioned, in many instances, you do have a in-depth investigation launched by regulator. And from our experience, the notification of a personal data breach often results in regulator scrutinizing the overall GDPR compliance. So they're not only going to look whether or not the incident could have been avoided, or whether you had, the right security measure in place, whether you handled the incident correctly, but they're also going to look whether you comply with all of your other obligations under GDPR. So it's really important that immediately after the incident, or immediately, after the notification, you start conducting a gap analysis to identify whether there is any area where you're not fully in compliance, any issue that you haven't addressed, because most of the time, this is what's going to happen. Regulators are going to start digging. So they're going to check whether you have a representative, whether you needed to appoint a DPO, and whether you have one or not. They're going to look at your website. So immediately, they're going to check any deficiency that they can see on your privacy statement. So it's really important to do this overall gap analysis exercise and to take measure immediately, and not wait before the regulator come to you, because they will start working on your case as soon as the notification kick in. And we've seen in many instances where our clients were sanctioned, and the sanction, the investigation started with a data breach, that they were sanctioned not only because of the data breach, but also for other infringement that has been identified during the investigation.
Yeah, that's interesting. That it can be a sanction from something that came out of the investigation with the original breach. We mentioned fines, and I kind of think it's worth spending a little bit of time about that. I know in the work that I do, I often get a lot of questions from clients around how is the fine going to be calculated, and I will readily admit I am not a lawyer. So probably not the right person to ask that question. So how is the fine actually calculated? Is it calculated out by one authority? If you've had to notify only one, do other authorities weigh in? Or if you've had to notify multiple, is it how complicated can it get? And Kelly, I think we lost you for a second, but I think you're back now. I'll maybe turn that over to you.
I am, and I apologise for having turned my video off. I'm with the clients at the moment, but it's very complicated, and I wish I could give you an answer to how the initial fine is calculated. It's a bit of a dark art, and it does rather depend on the relevant authority that you're dealing with. But it isn't as simple, unfortunately, as one authority deciding and that be the end of it. As we've seen recently with some quite high-profile cases involving social media companies, everybody wants to have a say. And so you end up pushing the draft decision out to all of the DPAs who have an interest, and they can all input. And inevitably, one has chosen as one's lead supervisory authority something nice and relatively predictable, like the DPC in Ireland. And then, unfortunately, for the clients, the rest of the 27 weigh in. And usually what that means is an increase in the fine. So it can be, although you make a strategic decision up front to designate your lead supervisory authority as one that you are happy with, unfortunately, you then end up with everybody else piling on and an increased fine.
Great. That does not sound like a good scenario to be in. And of course, it's not just the DPAs that you need to worry about in this scenario. I think we've kind of been spending a lot of time about them, spending some time talking about them, but there are other stakeholders involved. Data subjects themselves, for example. Maybe to Cedric, what can organizations do to ensure that they're handling, that side of it properly? If you do have to go down the route of notifying data subjects, are there other steps that they can take?
Yeah, so I think dealing with the SA or the DPAs is somehow the easy part. It's not that easy as we just discussed, but it's somehow the easy part in that process. Once you notify individuals, you're kind of opening a Pandora box, which is very, very difficult to close. So if you have a high risk breach, you end up notifying individuals. And what I do see in practice is that it does trigger, to put it simply, a huge mess of clients. What does that mean in practice? That means you're going to notify individuals. They're going to have questions about your GDPR compliance. They're going to have questions about the breach. They're going to exercise their right of access, right of deletion. And so if you take a concrete example, let's say you have a breach which covers 1 million people, which is not that big. That means in theory, you could have like 1 million folks, reaching out to your company. So once you notify individuals, there are a few things to think about. Have a call center ready, prepare template responses, have the right resources in place, and that can be significant resources to just reply to the questions of these folks, which are probably completely legitimate, but just be ready to reply to that. Like the GDPR provide for a specific timing to reply to individual rights, and that's pretty tight when you deal with a breach that need to contain DPA notifications, and in the meantime you do have like individuals reaching out to you. So that can be like a really, really big hurdle for companies. In terms of resources, something to think about is like all the resources are going to be allocated to replying to the breach from an IT standpoint, from a legal standpoint. a call center or like preparing the right replies, the regulatory investigation and the like are resources which will not be available to your company for regular GDPR compliance. So, that's something to think about and make sure you have the right, vendors, lawyers, staff, properly trained to make sure that you can handle this crisis when it happens. Another point which is worth mentioning in that respect is that we do see a trend in the EU, which is quite new for us, not for the folks which are in the US, but in the EU, we had very little class action in the past. We don't have the same legal culture, putting aside the UK, which is much closer to the US, but like in continental Europe, there was very little class action in the past, and that has changed. So once you have a breach for a big client, or a client which is known of the public, it's not unusual now to see class action plaintiff getting involved. And these guys tend to be quite creative. The best example of that is what's happening in Germany these days. Following the Volkswagen gas emission issue, they've created special vehicle entities to be able to file and try to seek damages on behalf of a class. So these are like new ways for plaintiff lawyers and individuals to seek damages. And I have had a few clients in that situation. So it's real. It happens concretely in continental Europe as well. The Netherlands as well is pretty well known for that. So in the past was mainly the UK, and now you need to look at other countries in Europe. Next to these like creative solutions, you have the new directive which should be implemented, which basically allow for quasi-class action as well. And then the GDPR itself allows NGOs to go before courts to seek damages. The one point here is that it's very easy for plaintiff lawyers to go after you once you have a decision which determine the facts. The facts are established, the breach is established. And then similar to what you see in competition law, you have follow-on litigation. So you, quote unquote, only need to prove the damages and the harm. And on that point, there is a trend of courts in different member states to recognize the harm when there's a breach. It's not automatic, but like the trend is definitely to recognize more and more the harm. So, it's something to think about as well. DPA's investigation, dealing with the DPA, handling all the individual's requests, but then next to that, you end up in litigation. So, the GDPR, how you manage your GDPR is significantly impacted, and the resources to handle that is really critical.
And Cedric, that was really helpful in walking that through. Kind of looking at the kind of the class action side, and maybe I'll kind of start with you, but then open it to everyone else. If you're in a scenario where you've gone down a kind of a long investigation with a regulator, and then you've also got questions coming in from data subjects and plaintiffs' counsel on the class action, do you expect, and kind of did you find generally that the types of questions and types of issues that the regulators are looking at the same as the class action, or do you end up kind of with two different types of investigations on different issues?
I think they are different. And the reason for that is that on the one hand, there are overlaps for sure, but like the DPA is more looking at GDPR compliance in the abstract and how it has been implemented at the company. While if well played by the plaintiff lawyers, they wait for the DPA decision to be out, and they don't have to look at whether there is a GDPR violation anymore, because once the DPA decision is out and provide that there is a GDPR violation, that fact is settled. So it's relatively easy just to move and like argue in the harm. And then, it goes without saying, but like when you end up in civil litigation, the issues are different. The game is slightly different. You're talking to a judge who doesn't understand data protection, who doesn't understand data breach, who doesn't understand IT in general in most cases. While when you deal with the DPA, you talk to individuals who know about data protection. So why there are overlaps, because the subject is the same. Like the approach and the type of arguments you're going to make are different.
That makes sense. So it sounds like the regulatory involvement may in some ways be the calm before the storm, and then it starts to become a real panic. Maybe let's switch gears a little bit, and I've also seeing there are kind of a few questions that have come through, and I would encourage everyone, if you've got questions in the audience, feel free to send them through. We do see them here. But kind of switching gears, we're talking about kind of what happens after you notify people. Let's take a different lens on it. How can you avoid notifying? Are there certain factors that you can look at to make a determination not to notify, say, a regulatory authority? Maybe Kelly, can I turn that to you?
Absolutely. I think there is a reaction almost when there's been an incident to notify, because everybody's so conscious of the 72-hour window that everybody rushes to look at whether or not you need to notify and who you need to notify. And I think people don't take the time to stop and actually consider, does this even come up to the requirements that Article 33 sets out for me to need to notify a supervisory authority at this point? And actually, it can take some time to do that analysis, and it'll obviously be an incomplete analysis, because inevitably within 72 hours, one does not have all of the facts. But if you take that time and actually speak to local council, if you think you might need to notify in the Netherlands, for example, it is worth speaking to Dutch council and actually getting their take on it to consider whether or not you've got a notifiable incident at all. Because once you've opened the can of worms and notified the regulators, you can't put the lid back on that can. It's open. And so that is one of the single most important decision you can take at that point, is whether or not you're going to notify. And so spending some time looking at the examples that the EDPB has given around notifiable incidents, spending some time thinking about what used to be the Article 29 Working Party guidelines on what you need to think about when you're assessing a risk arising from a breach is really valuable, because you can often, in my experience, get to a point where you feel that at least on the facts you know in the immediate aftermath of the incident, you don't need to notify. Now, that might change, of course, and as facts come out, you need to continually reevaluate that situation. But if you can delay that situation and delay the detonation of the bomb, if you like, then you have bought yourself some more time to think about how this all actually pans out. And similarly, if you think you need to notify the DPAs because it comes to the Article 33 standard, that doesn't automatically mean you need to notify data subjects. Article 34 has a higher threshold even still. So you need to work with your legal counsel in the relevant jurisdictions to really take a proper look at it and take a risk-based approach to whether or not you need to do any form of notifications.
Thanks, Haie. That's helpful. One of the things that we've talked about, and we had a question from the audience on this, is is doing this within the 72-hour window. But that, and you started to hit on this. Kind of determining when you actually start that clock is something that some organizations don't have familiarity with. So when, and I actually I'm maybe curious for everyone's input onto this one, but when do we all see the clock starting? Is it when someone's security operations center says, hey, there's been an alert, we might have been breached, or hopefully not then? How do you determine when to start that 72-hour stopwatch?
Happy to chime in. It's once you become aware of the breach, and the 72 hours is where possible. So there's a bit of a caveat there, which DPS interpret very restrictively, but there's still this caveat. So sometimes there is a bit more flexibility than 72 hours. Now, the question is, what does that mean to become aware of the breach? By you, they don't mean the legal counsel, they mean the company. That's one point. And the company doesn't mean the legal department, it means the company as such. Now, I think there it depends on the company risk appetite and on the facts. There are some instances where it's completely legitimate to wait because you need to do the right forensic to confirm whether the threshold has been met, to confirm what happened, and to actually reach the conclusion that you meet the threshold for Article 33 and there is a risk to individual's privacy. So, you know, like it's when we have a reasonable expectation that there was a personal data breach, that's what the EDPB says, it's its guidelines. You know, that's a point which tends to be interpreted with some level of flexibility by companies. You know, it's not unusual for companies to take a bit of an aggressive approach on that point. In practice, there is a way to mitigate that risk. It's like quite a few DPAs allow to notify in phases. So you can stop the clock, you know, do like a preliminary notification and then complete a notification afterward. So that's something to consider as well when you do run against the clock. The downside of that is once you notify, you have alarmed the DPA about the issue, which may trigger questions. But, you know, that's a way as well to stop the clock and avoid, you know, missing that deadline.
And I would add on that I mean, that 72 hours, you know, delay starts when you have make the determination that it's data protected by the GDPR that are affected. So because you don't want to notify a breach if in the end you find out that there is no EU citizen data that are being affected. So this is the reason why when an incident happens, you really need to calm down and first see, you know, what is affected and not immediately jump to the regulator because you need to make sure that this obligation applies to this incident.
And I think that's a great point. You know, one of the questions that we had from the audience, I think, is about kind of all of our experiences and you know, are we finding in these types of matters that clients know what type of data they hold? You know, if you're told this system was breached, do most clients know, okay, well, that system had personal data on it or not? And I certainly could chime in with my experience, which is at least my some of my clients did not know. Some of them did, but it's not necessarily simple. So you know, I don't know if
I'd totally agree with you, Spencer. I think it very much depends on the sophistication of the client. You know, lots of clients can tell you that if X server has been accessed, that there was personal data on there, but you know, often they can't tell you if it's GDPR covered personal data. To Anne-Gabrielle's point, you know, they may know that personal data has been affected, but at that point, they can't necessarily tell you which jurisdictions those data subjects are from. And you know, the point about slowing down and actually taking your time to think about what's going on here is so important. And you know, I'll reiterate it. If you don't think in advance about what you're doing, you set all kinds of hairs running, and you create an almighty mess for yourself. Without need in some cases. So to answer your original question, it really depends on the client. But yes, I have plenty of clients who don't know what data is on any given system that might have been breached or accessed.
And I assume that's the same for the other panelists as well. Maybe another question that we've gotten from the audience, going back to the point around, you know, multiple supervisor authorities. You know, and if you're in a scenario where there is a lead supervisory authority, do we find that clients, or is your advice generally to notify that lead supervisory authority and then kind of let them handle kind of it exclusively, or do you also send courtesy notifications to other supervisory authorities? What's the best practice there? And you know, Kelly, that you were originally talking about that, so maybe kind of turn it to you, but then ask Anne-Gabrielle and Cedric to chime in.
Yeah, I mean, in my experience, I've typically advised clients simply to notify the lead supervisory authority. If there's a particular reason that you might want to notify as a courtesy another DPA, then I don't think there's any prohibition on you doing that. And indeed, it might be to the client's benefit if they have, you know, let's say the lead supervisory authority is the CNIL, but they have major operations in Italy. They might, as a courtesy, want to let the grantee know, but they don't have to. And, you know, I kind of think that with all of the different DPAs, then I'd rather just let somebody else handle that.
I think we might be losing you, Kelly. And Gabrielle, is there anything that you wanted to add on to that?
I mean, fully agree with Kelly. I mean, this is the whole purpose of that one-stop shop mechanism, making sure that, when it's possible, you don't have to go to all data protection authority. I mean, I suppose that the only scenario where you would notify other data protection authorities and your lead supervisory authority is if you have a breach that only concern one given country. And basically, this is not a country where you have your lead, where here it would make probably more sense to go to the local data protection authority rather than the lead. But in practice, we see that also data protection authority themselves, they don't want, to have all of them involved. So most of the time, they're also trying, to make sure that one takes the lead. And if you have a lead authority, they're more happy to let that authority take the lead, because otherwise there is a risk also of conflicting decision from supervisory authority, which obviously, doesn't look great.
So on that point, of course, there is a case-by-case analysis to complete, but as a rule, unless the breach is really local, in which case you may consider notifying the local DPA, I would advise against notifying other DPAs, because that would force your one-stop shop. And that's the whole purpose of the one-stop shop, is to have to deal with one DPA. Of course, there are instances where it might make sense to notify the DPA if you have like a breach with, significant breach which makes the headline. Like there has been some breach in the past which were in every single news paper, then you may want to give a heads up, especially if you have established relationship with some people at the DPA. But as a rule, I always try to, or I recommend clients not to notify other DPAs and just deal with their lead DPA. Other DPAs will reach out to the lead DPA and get involved. They find a way to get involved if they want to.
They will find a way. Isn't that true? When the panelists and I all caught up, quickly before the session, and one of the things that we talked about is, that we've seen that, some clients don't necessarily know how much effort this can be. If you're kind of getting questions from the ICO and or another regulator and going back and forth with them, so kind of, I guess, thoughts on that. Is this like a, can this be done by kind of part-time by someone who kind of works in the company, or is it, one person, multiple people? What's the level of effort involved, and what's the duration?
I can give you a concrete example on that. I recently had a breach for a sophisticated multinational company with a 40+ team of privacy lawyers, globally. The breach was not that significant. Was talking about like a couple of millions individuals affected by the breach. At least 3 or 4 of the folks internally ended up doing that full time for nearly a year. And they ended up with 3 law firms working full steam ahead on the breach, plus a forensic team, plus a few experts, plus a PR team. So that gives you a sense of the scale of the resources which may be required in to deal with data breach. Of course, it depends the breach you're talking about. If you have a few HR data which is leaked, that's a completely different impact than dealing with consumer data which end up on the dark web. But it can be really, really significant.
Yeah, if it's a major breach, and as Cedric says, it's one that hits the news, you can write off your legal team for months, because that's all they'll be dealing with.
Yeah, that's certainly my experience. We had one kind of very specific question that I was kind of curious about. Do the DPAs, when they're kind of asking questions, are they looking at it unfavorably if you're kind of coming back and telling them that you don't know what data is in scope, or is on a particular server, if you don't know where in your network personal data might be stored? Is that a kind of a real hot button issue for them? And maybe kind of, Anne-Gabrielle, your experience on that?
Yeah, I mean, I would say that definitely, this is a red flag for regulator because, I mean, under GDPR, you have the obligation, to map your data to understand, what are your processing activities. So if you go to a regulator and say, well, we have no clue which data has been affected, then that would, obviously trigger some suspicion over, making this exercise, this mapping exercise, and probably they will have a bad first impression on your breach. So this is the reason why, I mean, one of the things that it's really important to do prior to any breach is, to the extent possible, to have a clear picture on where are your data, which data is stored where. I know that in practice it's extremely difficult, but that it's going to help a lot if you have a breach. Internally, to handle the breach, but also, externally, if you have to respond to data protection authority question.
And I know we only have a few minutes left, Anne-Gabrielle, that's a great segue, I think, to, trying to make this a little bit more positive and actionable for the attendees. Maybe to Cedric, is there anything else that you would recommend that companies do in advance of what is probably inevitable? Companies will get breached, but is there anything they can do in advance to make the managing of the GDPR easier?
Two things or three things. The first one is onboard a vendor. Make sure you have like an IT forensic company or like a tech company which can help you remediate the breach, do the forensic. When there is a breach, you don't have time to onboard someone. So, if you need to spend the first, half a day kind of dealing with which vendor you're going to pick, try to talk to them, to get them involved, complete an agreement, put the agreement in place to have them help you. It's already like a huge waste of time. So have a vendor onboarded. Like you have lawyers ready to help as well. Usually you're going to find information in security policy where you're going to have the contact details of the vendor you've decided to work with, and you're going to have the cell phone number of your lawyers. And then test, the incident response plan. So do a tabletop exercise. When you do this type of exercise, you always realize that there are issues that you have not thought about. Like the policy might look great on paper, but then when you actually have to implement, you realize that it doesn't work. There are instances where your network might be done, the email addresses are not working, so you need to have another way to contact the people. That's an example we see often. If the network is done, then you cannot send emails, so you cannot contact the right people. So there are a lot of things like that you realize when you do a tabletop. So onboard a vendor, lawyer, and do a tabletop exercise.
And I would add that also, make sure that you have the right insurance coverage, because I mean, it can cost a lot of money. So make sure that you have the right insurance coverage is very important. And also check whether your insurance company is imposing any specific requirement. Because, for instance, some insurance company only allow you to work with their preferred vendor. So if you onboard, vendor that are on the list, then you run the risk that it's not going to be covered, or other, insurance company asks you to notify within a certain time frame. So on top of the GDPR time frame, certain insurance company also request to be notified within a specific time frame. So it's also something that should be, carefully thought ahead of any incident.
Great, thanks. And Kelly, I don't know if we still have you. I know your video just went out. I was going to ask if there's anything else.
No, I see Bruce has appeared, so I think we're at time.
Yeah, well, Bruce, I can turn it back over to you. That was, I think, a really good organic discussion around managing the GDPR after data breach. I learned a lot. And Bruce, over to you.
Thank you, Spencer. Thank you, Anne-Gabrielle and Cedric and Kelly from the car. Thank you. Terrific. Thank you for the determination to stay with us.